sure they clear, and then I'll release them. Pardon? It's empty, they're cleared. Okay, you folks can go ahead. Thank you for your patience. Court does call the case, People State of Michigan versus Kellen Dixon.
Andrew Childers, people.
Kellen Dixon.
He didn't hear you. It is not, Judge. Apologies. Ready, Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Dixon. Mr. Dixon, please state your name for the record.
Kellen Dixon. Thank you.
Thank you, Judge. I spoke to Mr. Dixon. I understand from the notes he has been working to try to resolve the matter. He has asked that I set this matter for preliminary examination to try to get it moving forward, Your Honor.
All discoveries complete.
That's my understanding, Your Honor.
People have their witnesses available the 21st.
We go 1 week past that.
Any objection?
No, Your Honor.
Preliminary examination will be set January 28th, 2025, 9 a.m. in person before Judge Washington.
Judge, I'm sorry. My client just informed me he has a court date in Flint on that day.
February 4th work for everybody?
Yes, Judge.
That's fine.
February 4th, 2025, 9 a.m. before Judge Freshour.
Thank you, Judge. February 4th.
Bond will continue.
Let's call the office. Thank you, Judge.
Thank you. Court calls the case. People versus Ontario Woods.
So this is on behalf of people. Morning, Mayor. Edward Lucas on behalf of Ontario Woods.
Ontario Woods.
Your Honor, we'd like to set this for a preliminary examination.
All right, there is an added count for us. Let's do the arraignment on that.
Stand mute, waive reading.
All right.
Mr. Woods is the third co-defendant, Mr. Seeger and Mr. Burke.
Got it. All right, so he's being arraigned on count 4. Stood mute to those charges. All right, null discovery to your knowledge.
To my knowledge, it's complete.
And so we would be setting this one on the 21st. So preliminary examination in person, January 21st, 2025, 9 a.m. That's before Moore, correct?
Yes.
Before Judge Moore. Bond will continue. Thank you. Court calls case People versus Jaden Dodge.
After people, Stephanie Cannon, we have Mr. Dodge who's appearing by Zoom. Mr. Dodge, could you please state your name for the record?
Hi, my name is Jaden Dodge.
Thank you. What are we doing?
Your Honor, my client would like to exercise his right for a preliminary exam. I do believe all discovery has been provided.
People have their witnesses available the 21st.
Could we please go 1 week further off of that now?
Any objection to that?
No objection, Your Honor.
Preliminary examination, January 21st, 2028, 2025, 9 a.m. in person before Judge Washington.
That was January 28th, 2025, Judge Washington.
Yes, ma'am.
Thank you.
Bond will continue.
Thank you, Your Honor.
Court calls case People versus Michael Harris.
Good morning. We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, Quinn Withen, on behalf of Mr. Michael Harris. Mr. Harris, please state your name for the record.
Michael Harris.
All right, go
Today's
ahead.
date and time set for a probable cause conference and a bond violation hearing. With respect to the probable cause conference, we are respectfully requesting that this matter be set for preliminary examination. First available date. We do believe that we have all of the
That
discovery.
what?
And we have all of the discovery in this.
All right. And as to the bond violation,
Your Honor, my client is pleading, like to be heard on that because we'd like to address the bond. So I think in order to address the bond, you want to address the bond violation.
say again, I'm sorry.
So he'd like to address this bond. And then I think in order to address the bond, you have to address the bond violation. So in brief, the bond violation here is that he had contact with the complaining witness in this matter. He was found in a vehicle. He's driving a vehicle. She was also in. I've had a chance to speak with my client. He told me that the reason that he was in that vehicle is that he was taking the complaining witness to the hospital. Basically, they really don't have anybody but each other around here. He knew there was not supposed to be any contact. She came and picked him up. She complained that she had serious back issues and she was going to the hospital. She needed him.
Is there any medical that you have to go along with that? Or
He would not have it. He was stopped on the way to the hospital. The police arrested him. She did inform him that she informed the police, at least from what I know, that she had the back issues, that she needed to go to the hospital and he was taking her.
she was taken there?
He was taking her there. I don't know if she went. He was gone. He wasn't able to get follow up, and HIPAA won't allow us to do any follow up.
All right. Well, here's what I'm going to do. Would the people have their witnesses available the 21st? I'll set his preliminary examination January 21st, 2025, 9 a.m. before me. I'll let you go ahead and argue bond. I'm unlikely to do anything because it's a violation and I would need some.
So yes, I understand you. We absolutely understand. I talked to him about it. He would like to have the bond reinstated, even if the court wanted to up the level to a tether or something. But once you hear the bond, the issue on the bond violation, you understand why he did it, and it was in this.
No, I get why you're saying that, and I have the report, so I see some of that. But what I don't have is the other piece to it.
Right, I know, I understand what you're saying.
Okay,
so he's
here's
asking,
what I do. I'm not so. I'll say no at this time. Do the people know whether or not you have any information regarding the alleged victim in this case actually making it to the hospital and some documentation there?
She is. She back there in the back. She back there in the center.
Okay.
I don't know.
Do you know whether or not the alleged victim is saying that also, or no? Do we know?
Yeah.
Oh, she is. Oh, okay. So, ma'am, I'll just ask you this. I don't need to know specific details of anything. Did you make it to the hospital? Yes? Okay. I'm going to need some medical documentation. You can black out whatever you need to, but the fact that she went there, I need documentation of that. And then I certainly, Mr. Brown, will reconsider his bond at the time that I receive that. So she needs to get that from the hospital that she was there. I mean, even discharge paperwork will do for that purpose, but it's got to go to the prosecutor, to defense counsel, and then I can make my decision on things. Okay? So at this time, I'll deny the bond. I'll have it set. They can get that to me at any point. They can get it to me. Or he trying to read now? All right. So at this point, his bond will continue. All right. Get that. Okay.
Thank you.
Get that. Okay.
All right.
Thank you. Court calls case of People versus London Daughtry. Or, I guess it is Daughtry. Or Daughtry.
Good judge. Portia. Mr. Doctor. Sorry.
Andrew Childers, granted.
Doctor, state your name for the record.
London Daughtry.
The Daughtry. Apologies, Judge. I believe you should have a green sheet in the file.
I do.
Okay. This is the first pretrial on both of the PCCs on both of these files, Your Honor. Going to talk to the people about trying to get a global resolution on them, Your Honor.
January 30th, 2025, 9 a.m. Bond continues.
Thank you, Judge. January 30th. That's your next date, except for 9 a.m.
It's your last.
Oh, really?
Thank you, Judge.
Right.
I'll write some down.
Whoa. 6 counts, including first-degree criminal sexual conduct. That's life in prison territory. Notice how the lawyers are already signaling there might be a plea deal down the road, but if this hits trial, every single one of those charges will be in play. This is one of those jaw-dropping turns where you realize just how high the stakes are in this courtroom.
Who has to be in front of what?
Mr. Docket, who is the one who's Jax is supposed to be coming in.
Is Langston here?
Yes, he is.
The defendants here?
Yes.
Court does recall the case of the People versus Melvin Langston.
Andrew Childers, appearing on behalf of the people.
Good morning, Your Honor. Edward Dukas on behalf of Melvin Langston, who is approaching.
Your name? Melvin Langston. All right.
Your Honor, I was asking for an adjournment for further negotiations. It does sound like as of this morning, he has obtained counsel. I haven't signed a substitution or had that attorney reach out to me yet. I would be ready at the next hearing if that attorney.
All right. So you need to be here on time. You understand that? Yes, sir.
So I'd ask for just a 1-week adjournment.
Just one?
Well,
I'm going to go 2.
2 would work.
January 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you.
Thank you. Court calls case People versus Stephen Hensel.
Ashley Lonnie for the people.
Assistant Public Defender Jay Bell on behalf of Mr. Hensel, who approaches, Your Honor. Mr. Hensel, can you put the record?
Stephen James Hensel.
Thank you.
Thank you. Your Honor, I have checked with my office on a mitigation that we'd started several weeks ago. I think the holidays kind of held that up. I have no choice but to ask for an adjournment for that reason so that we can get that in over to the prosecution for a consideration on an offer. I would also like to ask to address bond briefly.
Okay, how much time are you going to need to try to complete the mitigation?
The mitigation, I believe, is already completed. It's just going through the editing process for the final draft. So I'm just going to ask for 2 weeks.
All right, but is that going to be enough time to get that there, have them review it, and then have meaningful discussion? That's all
I think so, Your Honor. I try to work rather quickly in cases in custodies.
Probable cause conference will be adjourned then to 23rd, 2025, 9 a.m. All right.
As to bond, Your Honor.
Briefly.
Thank you. I have spoken with Emily Kenders from the CMH. She has informed me that Mr. Hensel is agreeable to start services with community and mental health on the outside upon his release. He's really interested in therapy. He is engaged with CMH inside the jail. However, it's my understanding that he's not interested in starting on medications within the jail because he's had an experience where he's been over-medicated in the past. So we would be asking for his release on PR bond today so that he can start those services with community and mental health. As I stated, he is already with services in CMH as it stands.
Any response from the people?
I have the same concerns I've been expressing all along. I can understand that a person may have resistance to medication and a previous bad experience with medication. However, one of the biggest things that we see is that folks who require mental health or drug treatment don't dictate the terms of their mental health or drug treatment. They are, in a lot of ways, are asked to trust experts with what needs to happen with them. So the concern of the people is that the behaviors will continue on the outside like they did before, and that there will not be adequate protections for the safety of the community if the defendant is not receiving all the treatment that his care providers deem necessary.
All right. So just based upon what is said, and I still have the similar issues I think that I've expressed before. So
If I may,
the problem is going to be that what you said is it's almost an incongruent statement saying, I understand what may be the fear over medication, but then not having a willingness to start treatment while in custody. Yeah.
presently, I'm not symptomatic. I've been stable for months, and in October, when reviewed by the Center for Forensic Psychology, if you look at the report, there was no indication of any problematic symptoms. I was actually deemed pretty intelligent and understanding of what was going on. And I'm productive in here. I've been reading textbooks. I've been doing pretty high quality art, if I may. And I would say that the concerns of the people are noted, but I don't think it's necessary. I've never had homophobic slurs thrown at me. I've never had somebody threaten to cut my throat, and that's happened to me in here. And I would say I'd be safer on the outside.
So for those reasons, Your Honor, again, we would refresh our request and asking for bond for him.
I'm going to deny the request at this time. I mean, I'm going to have something in place. I think I've indicated that, Mr. Bellinger, and maybe once the mitigation gets through. I don't have a problem with release, but it's going to be under some structure and so that maybe you can explain this to your client and you can hear me clearly. It's going to be on the terms dictated by those professionals,
Understood.
not his terms, and then also the court's terms. That's how a release will happen in this.
Understood, Your Honor.
So at this time, bond is denied.
Thank you.
Bond. Votes for bond. Thanks. Court calls case People versus Gregory Douglas. This is my last.
Yes. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Douglas, who should be appearing via Zoom. Got it.
You think it may be? Okay. Gregory Douglas? Is that you?
Speaking, sir.
All
Speaking.
right.
You got? Am I here?
Yeah.
We can hear you now,
We
sir.
can hear you.
Thank you. Your
All
Honor.
right. I have a plea form that indicates he's going to plead guilty to the charge of larceny 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, count one would be dismissed. I noticed one problem here. The larceny 200 to 1,000 should be 1 year or $2,000 fine plus court costs like that.
I'm so sorry. Am I making a change? I apologize for that misread, that mistake on the plea form.
All right. And then there is an agreement of no delayed or deferred. All right, although I can't find the sentencing judge, but all right. That's the correct understanding.
That is correct. I will inform the court because Mr. Douglas is on Zoom. I did provide him with an advice of rights form via email. We did review that and discuss his rights regarding this. I also discussed with him a sentencing judge waiver, and he would waive his right to a sentencing judge.
All right.
And it is a no contest plea.
It's a no contest.
Yes.
There it is. All right. Sir, please raise your right hand. Do you solemnly affirm testimony it will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do swear.
All right. State your name again for the record.
Gregory Douglas.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of larceny 200 to 1,000. That is a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
I do understand.
All right. Do you understand what a no contest plea is?
I do understand, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
I do understand that.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I do understand that, Your Honor.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Valvo in the 15th District Court.
I understand, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. So understanding all of that, to the charge of larceny 200 to 1,000, how do you plead?
No contest, Your Honor.
All right. You understand that by pleading no contest, you'll not have a trial of any kind.
I understand, Your Honor.
All right. Because of that, and you reviewed an advice of rights form, is that correct?
I did, Your Honor, this morning.
All right. Did you have any questions regarding any of those rights?
I do not, Your Honor. I understand fully.
All right. And you understand that you'll be giving up specifically those rights. Well, you'll be giving up all of the rights on that form, but specifically the rights contained in paragraph 5 on that form.
Correct, Your Honor.
All right. You understand you're giving up your right to appeal of right.
I understand that. I'm giving up my right to appeal. I understand.
Well, appeal of right. You understand that?
I understand, Your Honor, fully.
All right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, no one has threatened me.
You're doing this voluntarily?
I am doing it voluntarily, yes, Your Honor.
And of your own free will?
Yes, Your Honor.
Court has been provided and is reviewing the Ann Arbor Police Department report for their case number 2340790. Any objection to the court reviewing that report?
No, Your Honor.
No, Your Honor.
Based upon a review of the report, the court does find a sufficient factual basis in which the court could determine the defendant's guilt of this offense. You're taking it to the higher charge also because of the value issue. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
February 6th at 1:30 before Judge Valvo.
February 6, 2025. I'm sorry, 1:30. 1:30 before Judge Valvo. Bond will continue.
Thank you very much, Your Honor.
Thank you.